compliance provider of choice for over 40,000 clients. We're a nationwide provider of registered agent, business registration, and licensing services and software. And we also extensively support nonprofit organizations, primarily through Labyrinth, our nonprofit brand. Our niche and what we strive to be best at in the world is simplifying regulatory requirements. We do that by first collecting information about our clients' businesses and the people that lead their organizations in secure and intuitive ways. We then store that information and process that data to reveal insights about what requirements may apply to them and how best to meet them. And then finally, by transmitting that information to government agencies on our clients' behalf so they can skip the paperwork and instead focus on running their businesses. And if you haven't grasped it already, that pretty much strictly defines the process of managing beneficial ownership reporting requirements. So let's get into the agenda for today's presentation. Today, we're going to talk about one of the buzziest topics in business compliance, especially since last week: beneficial ownership information, or BOI, reporting requirements brought about by the Corporate Transparency Act. So here's the agenda. We are going to be covering beneficial ownership information reporting requirements, why reporting BOI should be a priority, what it takes to file a BOI report, and how to manage and simplify the BOI reporting process. This presentation is scheduled to be about 30 minutes in length with 10 to 15 minutes of Q&A afterwards. We may get a little bit lengthier than that given all that's transpired over the recent months. But before we get into that, I'm going to give you our very first poll question just to get a feel for the audience and what your level of awareness really is. Okay, launching now. Just curious, how many of you out there are familiar with BOI reporting requirements? No judgment here. Please be truthful with us. Let us know it's okay. There's no shame in saying, I don't really watch that much news coverage, if I can help it, on regulatory requirements. I would completely understand that. Okay, it looks like the bulk of folks who have responded are saying that you've heard of them, but not quite sure if they apply to you. And I hope to be able to illuminate those requirements through today's presentation. Thank you very much for your contribution. I'll close that poll. Okay. So let me apologize right up front for all of the acronyms that we'll be using in this presentation. The federal government loves its acronyms. There's an acronym for everything, so you'll hear many of them. And I'm going to do my best to define each of them as we go to make this as easy as possible to follow. So I'll first start by explaining the why behind BOI reporting. The whole reason BOI reporting is now required is to accomplish the objectives of a law that was passed by Congress in 2021, known as the Corporate Transparency Act, or CTA. The CTA was passed as part of the National Defense Authorization Act, and its primary objective is to prevent money laundering, terrorism financing, and other illicit financial activities by promoting transparency within corporate structures. The requirement impacts over 30 million reporting companies registered in the US, so quite broad-ranging. So how does BOI reporting support the CTA's objectives? Well, by requiring those 30 plus million entities to report information about the individuals who control their operations to the federal government. These individuals are known as beneficial owners, hence the term beneficial ownership information reporting. By revealing the individuals who benefit from a business, it becomes more challenging for criminals to operate that business anonymously. So, of course, you're all familiar with the saying, follow the money. BOI reporting allows the federal government to more easily follow the money and identify bad actors behind complex corporate structures. The agency responsible for collecting BOI is the Financial Crimes Enforcement Network, or FinCEN. FinCEN is a division of the U.S. Department of the Treasury, and it has issued much of the educational information about this requirement, developed a filing process, and it oversees enforcement. There's a quote on the screen from FinCEN which describes how BOI helps it to accomplish its purposes. It says, BOI can provide essential information to law enforcement, intelligence, and national security professionals as they work to protect the United States from bad actors who exploit anonymous shell companies to engage in money laundering, corruption, sanctions and tax evasion, drug trafficking, fraud, and a host of other criminal offenses with impunity, while legitimate businesses suffer from their misdeeds. So that's where it all came from. That's why it matters and why it exists. Now, while the CTA is a federal act and FinCEN is a federal agency, you should be aware that multiple states are actively considering or have already passed similar requirements. For example, DC introduced a similar reporting requirement way back in 2020. They were leading the charge. And both New York and South Dakota have passed their own laws in 2024. California and Massachusetts are also considering bills that would require additional state-level BOI report submissions for entities within their borders. Now, today we're going to focus on the federal requirement, but just know that there are these state-level requirements out there, and they're on the rise. So what is a reporting company? It's a legal entity required to report BOI that is not exempt from the CTA. Technically, there are two categories of reporting companies: domestic, which are formed under US laws, and foreign, that are formed under the laws of foreign countries. Given today's audience, we'll focus on domestic reporting companies. Both corporations and LLCs, far and away the most common entity types out there, they are considered reporting companies if they don't qualify for an exemption. But it's not just corporations and LLCs that are impacted. Virtually all other legal entities that are created by filing paperwork with the Secretary of State or any similar office are also required to report if they don't qualify for exemption. Now, there are a few business structures that don't file paperwork with the Secretary of State, but it's only a very small handful of them. Sole proprietorships, general partnerships, and trusts are in that group, and as a result, they're generally excluded from reporting BOI. Key word there being exclusion, not exemption. Okay, two different things. They're sort of carved out from the reporting requirements versus those that would typically be required but may qualify for exemptions. And we'll cover those exemptions briefly in a moment. So how can you tell if your business is a reporting company? Because that's really what it comes down to. If your business is a reporting company, then you have a reporting obligation. Well, as we've established, virtually all legal entities registered in the US are required to report if they're not exempt. As long as your business structure isn't a sole proprietorship, general partnership, or trust, it really comes down to whether your organization qualifies for exemption. But before you get too excited thinking you'll qualify for those exemptions, you should be aware that in the lead up to the filing window opening on January 1st of 2024, FinCEN provided some staggering estimates of how many reporting companies there are. You set aside those three exceptions that we just mentioned. They estimated that roughly 32 million reporting companies existed at the start of the year, and that another roughly 5 million new reporting companies would be registered in 2024 and every year thereafter. So we might be up to 37 million filings due already, and likely more than that because we're already 2 months into 2025. That's roughly 97% of all organizations registered in the US. Put simply, BOI reporting requirements were intended to impact virtually all businesses. Now, with that being said, I'm going to launch my next poll question. It's really 3 questions in one. Have you reported BOI yet? Why or why not? I'm curious to know. Again, no judgment. All of those who've joined so far are likely aware of the recent announcement just last week that came out from FinCEN suggesting that a new deadline has been released. If you haven't filed yet, it's not too late. You still have until February 21st to do, March 21st to do so. So if you haven't done it, no harm, no foul. There are no penalties for that just yet, but the time is now to take action. So let's hear it. How many folks out there have actually done the BOI report yet? Oh, very interesting. Okay, so it's about a 50-50 split. Okay. This is great. Yeah. It looks like the majority of folks, there are more people who have not reported so far than there are that have. And that's okay. No judgment. That's totally fine. We're here to learn together. And hopefully we can help you out if you need support for those filings. Sounds like the majority of people who have done the filing did it for their own organization. Fairly typical. And it looks like there's still quite a few people holding out to see whether or not the Corporate Transparency Act will be struck down. Okay. Thank you guys for your input. Very helpful. I'll close that poll. All right. Let's talk exemptions. Despite the fact that very few companies will fall into these categories, okay, I got to start with that disclaimer. I would be remiss if I didn't mention that there are 23 exemptions. The big one to be aware of that impacts the broadest variety of companies is the large operating company exemption. It's the only broadly applicable exemption that there is. Your entity generally qualifies for it if it has more than 20 full-time employees, a U.S. operating presence, and reported $5 million in gross receipts or sales on last year's tax return. Note that that exemption extends to subsidiaries of entities that meet those criteria. You got to meet all three, though, in order to qualify for it. The rest of the exemption categories, and there are quite a few, they're very narrow and generally only apply to highly regulated organizations like banks or state licensed insurance producers or public utilities, maybe nonprofits with federal tax exemptions. Note that nonprofits that aren't federally tax exempt, they generally wouldn't qualify for the exemption. So I've got a quick follow-up poll here. Let's find out how many of you folks have entities that are likely to qualify for the large operating company exemption. The answers to the three questions on your screen will yield the answer. We will be able to reply to you after the presentation today and let you know whether or not you are in the category for this exemption. So does your organization have 20 or fewer full-time employees? Did your organization report gross receipts or sales of $5 million or less on its federal tax return last year? Does your organization regularly conduct business at a physical location in the U.S.? If you check all the boxes, you may just qualify for the large operating company exemption. Okay, very good. Thank you guys for the contribution there. We'll be in touch after the presentation to let you know which category you fall into. Close that poll down. Okay, so we've established that virtually all business owners will be impacted. Now, let's briefly discuss what a beneficial owner actually is. Well, for one, a beneficial owner is a natural person. Business entities cannot be listed as beneficial owners. They must be human beings. And to identify which human beings or beings, because there can be more than one, would qualify as beneficial owners of your business, there are two simple questions you need to ask. First is, does this person own or control at least 25% of my legal entity? If yes, they're a beneficial owner. The second question would be, does this person exercise substantial control over my legal entity? Again, if the answer is yes, they are a beneficial owner. It's as simple as that. Pretty easy and straightforward to figure out. The substantial control element, however, is open to interpretation. What does substantial control actually mean? Well, we have the answer. Let's figure that out next. FinCEN has provided some helpful guidance to help us determine whether or not an individual has substantial control. FinCEN has stated that it constitutes substantial control if the individual is a senior officer of the reporting company. And this would include president, CEO, general counsel, COO, CFO, all those roles that come to mind immediately. But it's not the title that matters. This is vitally important. Their title could be janitor. it would not matter. They may still be beneficial owners if they perform functions that are normally reserved for senior officers. The other test, can they appoint or remove senior officers, board directors, or similar bodies? If the answer is yes, then they would also have substantial control. Can they control important decisions about the business's direction, its finances, or its legal structure? All of those things would constitute substantial control. Or has any other form of substantial control over the reporting company existed? That last criteria is really a catch-all that ensures that unique or creative control structures can't circumvent the reporting requirements. Now, you should note that entities formed on or after January 1st of last year, January 1, 2024, they may also need to report information about the individual who directly filed the document that creates or registers the company. And if more than one person is involved in that filing process, the person who is primarily responsible for directing or controlling the filing may also need to be reported. These people are referred to as company applicants. So I'll take you through this just once more, because there's a lot to take in there. For entities that are formed January 1st, 2024 or after, you'll need to report on your beneficial ownership information report there the names of any company applicants. Now, who is a company applicant? It would be either the individual who directly filed the document to create or register a company and the person who directed them to do so, if there is one. Okay. So a good example would be if you're working with a business like Harbor Compliance and you've directed us to do a filing to form your legal entity. In that case, we would be your company applicant, and there would also be your name listed on there as a company applicant because you would have been the one that directed us to do that. Okay. It's also vital to understand that BOI reporting was not designed to be a once and done filing. You need to remember that BOI reporting allows the federal government to more easily follow the money and identify bad actors behind complex corporate structures. And that is only possible if the information that FinCEN has in its database is on file and up to date at all times. And that means that for any BOI reported to FinCEN that changes, it must be updated in their database as soon as it changes. As soon as it becomes outdated, there must be an additional filing submitted. Accordingly, FinCEN offers report types that collect not only the initial information submissions, but also accept updates and corrections as well. Updated reports are used to notify FinCEN of changes to reported BOI or changes to an entity's exemption eligibility. For example, consider a nonprofit corporation formed this year that intends to apply for federal tax exemption. The IRS's tax exemption process may take longer than the 30 days that are allowed before the report needs to be submitted. This means the nonprofit will need to report BOI to FinCEN until its federal tax exemption is granted. Okay. Once that tax exempt designation is granted by the IRS, then the nonprofit can file an updated report to let FinCEN know, I no longer need to submit this. I'm a federally tax exempt entity. But in the meantime, that in between time from when it's formed to when it has actually received its federal tax exemption, it would be on the hook for submitting beneficial ownership information reports. Finally, I want to go over the corrected reports. FinCEN understands that some honest mistakes in reporting are going to be inevitable, and the agency offers corrected reports to fix inaccuracies in previously submitted BOI filings. Entities have 30 days to submit a corrected BOI report from the date the owner became aware of the inaccuracy. While technically speaking, it's possible for a business to only have to report BOI once, that assumes that none of the underlying information changes over its entire life cycle, which is fairly unlikely. So at this point, we've really covered the basics. We've discussed why the Corporate Transparency Act exists and how BOI reporting supports law enforcement in identifying bad actors behind shell companies. We've covered the fact that this is a federal reporting requirement and that similar state level requirements are on the rise. We've defined what a reporting company is and clarified that virtually every business registered in the US may fall under that definition. And we've discussed how to identify your company's beneficial owners and company applicants. So next, let's discuss why reporting BOI should be a priority for every business. So let me be upfront that we approach these requirements from a practical standpoint. We realize this is a business audience and you're a pragmatic bunch, right? We are not here to discuss the merits of the Corporate Transparency Act and whether or not BOI reporting is a good thing that the government should be enforcing. We are here to talk about the real world, on the ground reasons why you can't afford to ignore this. So here they are, plain and simple. Reporting under the Corporate Transparency Act is the law. Breaking that law has serious consequences. And as I mentioned earlier, the new March 21st, 2025 deadline, that is 2025, my mistake there, is fast approaching. The time to act is right now. So now let's talk a bit about the law's durability and what the consequences for breaking it actually are. We've spent over a year discussing this requirement with clients. Hundreds of conversations filled with speculation and some wishful thinking about why it might or might not hold up. And the legal battle has really been a roller coaster, if you've been following it. Business owners hoped the rule would be struck down, and a last-minute court challenge temporarily paused enforcement just before the original January 1st, 2025 deadline. Since then, courts have gone back and forth, but as of last week, FinCEN set that new filing deadline of March 21st, 2025. And at this point, the legal uncertainty, it's behind us. The requirement stands, and reports are due in just a few weeks. We've confirmed this through direct conversations with FinCEN leadership, industry experts, and top attorneys. It is very likely that this requirement is here to stay, and the time to act is right now. And now that enforcement has resumed, BOI reporting is no longer optional as it was for a few of those in between months. Not submitting an accurate report on time carries significant penalties. And there are two ways that businesses can get in trouble with BOI reporting. The first is to purposefully provide or attempt to provide false information in a BOI report. And the second would be to purposefully fail to provide a complete updated BOI report. In either case, the business may face civil or criminal penalties. As far as civil penalties are concerned, violations can result in fines of up to $591 a day, capped at $11,280 per violation. And with respect to criminal penalties, up to 2 years of imprisonment can be the result. And this is not an either-or scenario. Civil and criminal penalties can be enforced simultaneously, which is scary stuff. Now, I've been giving a version of this very same presentation on at least a monthly basis since the beginning of last year. And up until Q4 of 2024, I was telling people there are really two approaches to avoiding penalties. I used to say the best approach for some businesses, not everyone, but some businesses, would be to closely scrutinize the exemption criteria, define the beneficial owners for all their entities, and that usually meant hiring an attorney to make a legal determination on whether or not to report. That would ensure BOI was reported for only the entities that were absolutely required to provide it. But now, given how little time is left before the filing deadline, there's really only one practical solution: proactively report as soon as possible. Even if you have money to hire an attorney to review the specific details of your situation, it's doubtful whether there'd be enough time to conduct a full-blown legal review. And instead of risking it, business owners can immediately report BOI for all entities that could reasonably be impacted. Skip that paralysis by analysis and put the risk of penalties behind you as fast as possible. Keep in mind, there are no penalties for submitting unnecessary reports. There's no issues with that. If you think you might be exempt, but you're not 100% sure, there's not a lot of downside to just submitting the report. If in the future you find out you're actually exempt, you can always file an updated report, submit that, and eliminate the need to maintain the information going forward. So that one's pretty straightforward. Now, that being said, if you are already of the mind that you are going to identify a professional attorney to help you navigate this requirement so you can be completely certain that you're submitting only that which is necessary, that is totally fine. Okay. There's no judgment here. That's fine. In fact, we have develop partnerships with leading law firms able to give you that type of advice. So don't hesitate to reach out to us directly. We can make a referral, get you in touch with folks who know this requirement front to back. But from our perspective, what's been most practical for most businesses has been to simply just do the filing. There's not a lot of cost to it, not a lot of time involved, and you can put it out of your mind and move on with running your business. So, as I've mentioned, we've spoken with many business owners about BOI reporting and the CTA in general. And two things stand out in their responses. First is just how little awareness there is around this topic. Despite the fact that the reporting window has been open since January 1st of last year, many business owners haven't been keeping up with the requirements. Even now, with lots of national news coverage on the legal wrangling around this topic, awareness is severely lacking. The second thing we frequently hear may help explain the first, though. It's that business owners are expecting their accountants or attorneys to at least notify them of it and potentially even handle it. And this is where business owners should really sit up and listen. Because in general, most attorneys and accountants don't really have a plan for offering BOI reporting services for a few different reasons. It makes sense when you think it through. First, completing these BOI reports means collecting a whole bunch and storing a whole bunch of sensitive, personally identifiable information, or PII. And the second item is that since BOI reporting isn't a once and done filing, this represents an ongoing maintenance obligation for whoever takes it on. You put those two things together, and they present a technology challenge and a data security risk that a lot of law and accounting firms just don't really want to deal with. And it's not always just a matter of preference for these firms either. Many of them have internal compliance protocols that limit their ability to provide this kind of service directly to their clients. They feel like it's just too close to the line when it comes to unlicensed practice of law, for instance, if you're an accountant. Of course, accountants and attorneys want to meet this need for their clients. They obviously do. So many of them are exploring partnering with third-party providers like Harbor Compliance to handle the filing for their clients. And that way they can educate their clients the way that they expect to. They get to be that trusted advisor giving them instruction on how to navigate it, but they don't get stuck holding the bag with respect to storing that information and actually doing the last leg of delivery on the filings themselves. Accountants and attorneys are definitely going to play a big role in helping clients meet these BOI requirements. I don't mean to suggest that they're not going to be involved, they're not going to touch it, or they won't bring it up to their clients. Many definitely will. But for the most part, it probably won't involve submitting BOI reports for their clients. Rather, they're going to refer that business. They're going to pass those clients to partners to manage the filing requirements, because what they're looking for is an organization with BOI reporting technology that is able to either build this into the back office process for their firm and provide a seamless brand experience, or just do the handoff so that vendor can actually manage the filing on their behalf so that they can feel confident their clients have been, their needs have been met. And that's what Harbor Compliance is here to help with. So if there are any accountants or attorneys on the call that find themselves in that situation, don't hesitate to reach out. We'd be happy to help. All that being said, we have a takeaway for everyone on the call today. Here's your homework assignment. Bear in mind that maintaining legal compliance is not only the law, it is a best practice for businesses of all kinds. BOI reporting is now a reality of operating a compliant business. So your job immediately after this presentation is take this information back, share it, share what you've learned with your broad organization and ownership. As we've covered, it's a fact. It is an established reality that many business owners don't know what's going on with respect to BOI reporting. They don't know the risks of failing to report. So don't let your organization fall into that category. For all the attorneys and CPAs on the call, you may not need or want to be experts in the CTA, and I totally get that. Yet your clients do need to know about these requirements and how it impacts them. And we hope this presentation gives you high-level information to share with your clients to find a solution. Regardless of your role or your firm's position on offering a solution, take that initiative to start the conversation. Encourage everyone in your org to educate themselves on the topic and advocate for prioritizing compliance. Okay, so now before we get into what it takes to manage BOI reporting, we're going to launch another poll. How are you managing the process? Curious to hear what the plan is going forward. Obviously, the requirement is here now. Deadline is coming up soon, March 21st. Everything needs to be submitted by. Time to start gathering that detail. We'll go into this in a little bit as we go through the process, but the amount of time it takes to gather this information is longer than many people think. So it's good to get a jump on it. Looks like the bulk of the audience is planning to do that filing on your own, and that's fine. Totally fine. What we care most about is that you folks leave educated on the requirement, know what needs to be done, are able to solve the problem. We'd love to help you, of course, and for a number of reasons we're going to cover soon, it may make sense to look for a managed solution. But just the same, what matters most is that you guys avoid those penalties, meet that requirement timely. All right, thank you guys for the responses. Very helpful. I'll close that poll. Okay. Thank you very much for that. Let's move on and discuss just what you'll be getting into by attempting to manage BOI reporting on your own. On the whole, BOI reporting can be thought of in four broad phases: research, file, monitor, and maintain. In the research phase, you'll be gathering information on the company and the individuals you're reporting on. Every organization must report two types of information, both company and individual. Required company info, it's pretty basic. It includes things like the name of the company's address, the jurisdiction in which it was formed. These details are pretty straightforward. The same goes for the individual details. They're also fairly easy. You'll need name, date of birth, residential address for these folks. Note, as I mentioned before, there are two different categories of individuals that can be listed on that BOI report. You've got your beneficial owners, those are the big ones, and of course the company applicants. The beneficial owners are the individuals with ownership or substantial control over the entity. Every report needs to have at least one, but there can be many. Technically speaking, there's no limit. You can have an unlimited number of beneficial owners for a single reporting company. But on the other hand, company applicants are those folks who were involved in either directly creating or causing the reporting company to be created. It's generally the person who files the formation paperwork with the Secretary of State and the person who directed them to do that. Company applicants must only be listed on reports filed by reporting companies that were formed in 2024 or later. So if your entity was formed prior to 2024, this rule doesn't apply to you. But if there are any fairly new entities on the call, then you need to be aware of this company applicant requirement. Real quick note before we move on, related to FinCEN IDs. FinCEN can issue IDs to both individuals and companies. The ID number can then be entered into the BOI report, eliminating the need to type in their specific details for each filing. And this approach saves time, especially for clients with multiple entities and beneficial owners. So keep an eye out for that if you're doing the filing on your own. At first, gathering information to complete a BOI report seems pretty simple and straightforward, but there's more to it than meets the eye. Before you reach out and start collecting information from all your beneficial owners and company applicants, you need to consider two things. First is the security of the data you're collecting, and the second is the time you'll need to invest to collect it. First up, data security. The residential addresses, images of government IDs, and other personal details required in a BOI report constitute personally identifiable information, or PII. You need to have certain security protocols in place when transferring and storing PII to prevent this sensitive information from falling into the wrong hands. Emailing that stuff back and forth, texting it back and forth is a no-no. Sharing it via shared documents also isn't secure. This can be a real risk to your business. Now, let's consider how much time you'll invest in collecting BOI. FinCEN originally estimated completing a single BOI report could take about 3 hours. But in our experience, that was overgenerous. Many businesses are taking 2 to 4 months to collect required information. The time to start this process again is right now. If you're dealing with multiple entities, this message is even more urgent. Now, imagine being a trusted admin at a multi-entity organization reporting BOI for just a moment. Put yourself in their shoes. The CEO tells you to gather everything required to report BOI for several entities under the parent company umbrella. Now, you'll need to navigate the ownership and management structure of every one of the entities in the business to find the right individuals, locate their contact information, contact them all by phone, not by email, because that would be unsecure. You'll need to protect that PII and field all of their follow-up questions about why this is necessary and what the information is being used for. And that's all before you've even filed anything. Once you've run the gauntlet of collecting all the required information securely, it's time to access the FinCEN Beneficial Ownership Secure System, or BOSS portal, and file. In our experience, the BOSS itself is fairly usable, but just like any piece of technology, it's got its imperfections. The main one is that it tends to time out if a report isn't completed quickly enough. So put yourself back in that admin shoes and imagine getting 3/4 of the way through the 58 question form before being asked to take care of another task, which happens all the time in the life of an admin. When you revisit that form, you realize the system timed out and you have to start back at square one. Not a fun time. FinCEN has expressed concerns about their portal's ability to handle the millions of reports that will need to be submitted before the deadline. This is all the more reason to get started immediately and get your reports out of the way before the rush is upon us. And frankly, the rush is happening right now. Note that transmitting data in high volume is possible using FinCEN's API. And instead of using the BOSS system to file individual reports manually, third-party providers can get access to past data directly into the system. And this is a publicly available capability. However, it takes technical know-how and an investment in that automation that many firms and even service providers just aren't in a position to make. And so anyone looking to outsource or handle BOI reports at scale should know to ask this question of their provider. Once the report has been submitted, you have to consider securely storing reported information, as changes to that data will trigger future reports. In an ideal scenario, you'll have a secure web-based app that stores reported data automatically, so you don't need to worry about starting every corrected or updated report from scratch. And that brings us to Monitor. I cannot stress enough the recurring nature of BOI reporting. It's not a once and done filing, okay? Don't treat it as such. FinCEN expects to have up-to-date information at all times. And in practice, what that means is you'll be taking a screenshot of whatever data you report to FinCEN the first time around. You'll share it with all of your beneficial owners, and then you'll take time to routinely review the information to make sure you catch changes as early as possible. You'll be building a new business process that monitors aspects of your beneficial owners' lives that, frankly, you may never have been privy to before. You'll need to start proactively asking beneficial owners if and when they plan to move residences, when they plan to get married that might result in a change to their legal names, etc. These are processes you'll need to build in to your day-to-day management. And monitoring doesn't stop with individuals. You'll need to be in close touch with anyone able to make changes to your company level details as well. So if your business is moving offices, an updated report may be triggered because the location could change. If you're planning to register a new DBA or trade name as part of a rebranding project or something along those lines, time to file another report. If you're planning to sell an ownership stake to raise funds, you could be facing yet another updated report. And monitoring extends also to the requirement itself. As we've covered, there are lots of different legal challenges that exist to the CTA. None of them are likely to be resolved anytime soon. The CTA, we believe, based on the best evidence that we have from the experts, is here to stay. It's not going away, but you need to monitor this requirement. That said, future legal challenges could impact reporting requirements for certain classes of businesses or certain groups. You'll also need to stay on top of any new requirements or guidance released by FinCEN, as well as any new copycat legislation at the state level. And finally, you actually have to combine all that information together and act on the changes to all the data you're monitoring by submitting updated and corrected reports. You have to react to what it is that you're monitoring. Both must be submitted within 30 days of learning of the underlying change event. And failure to do so risks all the same penalties as not submitting the initial report on time. So what does it take to manage BOI reporting compliance? Well, quite a lot. You'll need to invest time in building systems and processes to securely gather and store all the required information. You'll need time and expertise to prepare the filings and navigate the BOSS portal filing process. You'll need a system of notifications to track changes to the reported information and the filing requirements itself. You'll need the time and resources to complete updated and corrected reports every time something inevitably changes. And you'll need the discipline, which may be the hardest one, to make these processes part of your daily routine. You need all of that, or you could work with a third-party provider like Harbor Compliance that can help you manage your reporting requirements and make this simple. So with that, you've come this far, you're 41 minutes in. You deserve to have your questions answered. Let's take a look at the Q&A that have come in so far through the conversation. Okay, right off the top, there's a question here. Is the BOI reporting required annually? The answer is no. There is not an annual filing requirement for beneficial ownership information reports. However, as we just mentioned, if any of the information that has been reported on your initial filing changes, you'll have just 30 days to update that with FinCEN. So it's an ongoing filing requirement, and it is something that will recur, but the basis on which it refers is not annual. It's not on any timeline except the timeline on which the information changes. I've got a question here. What does Secretary of State mean? That's a good question. I can zoom out a little bit. So what we're really talking about when we reference Secretary of State, and you'll see this written in FinCEN's own guidelines, the Secretary of State would be the office within a given jurisdiction, usually a state in the United States or a territory, where the business was legally incorporated or formed. So if you formed an LLC and you filed articles of organization to create that entity, or if you incorporated a new corporation, you filed articles of incorporation. The office that you filed that paperwork with, that is generally referred to as the Secretary of State. It goes by a few different names, but the equivalent office in any jurisdiction, that's really what we're looking for. If that paperwork was submitted to create that legal entity and create that separate entity from your own, then that is going to be a trigger for creating a reporting company. Thank you, Scott, for pointing out the typo. That's a little embarrassing. You're right. The date is 3/21/25, not 24. I realize that it is no longer the year 2024. Sorry about that. Okay, I've got a question here on whether or not BOI reporting is one time. The answer is no, clearly no. Technically speaking, theoretically, you might be able to get away with a single one-time filing if, upon filing your initial report, nothing ever changes that was submitted on that initial one. It's fairly unlikely. So generally speaking, it is not a one-time report, and it will need to be updated anytime your underlying information changes. Is there a way to find out if a BOI report has already been filed? That is an interesting question. I have not had to answer that question directly before. There was almost certainly a receipt generated if a filing was submitted that would have come through the BOSS portal. That's the way the system is designed to work. I know that we've gotten those approvals for our own clients. And so the client would very likely be aware if the report has been filed already, because that provider would have sent them the receipt effectively to let them know that it's been submitted. That would be the first place that I would go. I would ask the client whether or not they have proof of the filing. Does it take a long time to complete online? Well, I guess that really depends. It really depends on how complex your filing is. Remember, we stated already that the beneficial ownership list of individuals who need to be included there is theoretically unlimited. You could have quite a few beneficial owners listed on a given report. So the more information that you need to enter into the portal, the longer it will take. In most cases, if you sit down and submit that filing, it shouldn't take a tremendous amount of time if you have everything available at your fingertips. FinCEN estimated it should take the average person about 3 hours to gather all the information and do the filing. But as I mentioned, we've gotten lots of examples of clients of ours who ordered service and then basically took 2, 3, 4 months to gather all of the information. Now, they weren't in a big rush because those orders were placed in mid-2024. So they took their sweet time gathering that information before the filing was submitted. But it can take quite a while to gather all these details. Go back to the example of the admin at the multi-entity company having to go through the phone tree and call every person one by one to get their information. It can be time consuming. Is there a cost attached to the BOI report? There is not a filing fee for submitting the report through the BOSS portal. FinCEN will not charge you for submitting this. Now, if you work with a third-party provider, then they will certainly charge you. This is one situation that I've seen come up a few different times. There are some providers of BOI reporting services out there that are fairly misleading in the way that they're presenting this, whether that's intentional or not. I've had multiple clients come to me and say, oh, I went to go do my filing through the BOSS portal and it tried to charge me. And that's a big red flag. The alarm should be going off. That's a big indication you are not on the BOSS portal. You are on a third-party provider website. And if you're paying anything to that third-party provider, recognize you're not submitting the filing to FinCEN. You're submitting it to a third-party company, and they would likely be trying to submit that on your behalf. Good question here. Is a company exempt from filing if it is a wholly owned subsidiary of an exempt parent company? In some cases, yes. For example, the large operating company exemption. That was the big one that we talked about early on. If you are exempt under that exemption, then subsidiaries of those exempt entities are also exempt. But that, is not the case for every type of exemption. I'd encourage you, check out the exemption quiz on our website. You can visit harborcompliance.com, go to our information center, check out the BOI reporting guide. On the very front page of that guide, there's a link to an exemption quiz, and it can help you figure out whether or not your entity will be exempt. Good question from Jenna on who the beneficial owners and company applicants of a nonprofit are. The company applicant piece is actually fairly straightforward. Those are the individuals who either completed the filing to incorporate the nonprofit or the individual who directed them, probably both. When it comes to beneficial owners, you need to go back to that test. Obviously, there is no ownership in a nonprofit. That's not the way that organizing documents work. But the individuals who can control and have substantial control over the operations of that organization would be the ones to look into. So we talked about, major officers, chief officers of the organization, individuals who can make decisions with respect to how the business is run, where it operates, legal structure, all those details. You can go through that series of test questions to figure out who qualifies as the beneficial owner of the nonprofit. Can the beneficial owner and company applicant be the same person? Absolutely. Yeah, it happens all the time. If you're a founder and you did the filing on your own, then you both submitted the application and became a company applicant, and you are the beneficial owner because you are the sole owner and proprietor of that business. Okay. I'm running through a few of these. I see a couple that were duplicates. I think we answered some of these. Ooh, is a joint venture formed by two larger operating companies required to report? That's a good question. If there's a legal entity that's formed a reporting company and paperwork has been submitted to a Secretary of State office or equivalent office, and it doesn't fall into those exclusion categories, possibly, yeah. If you formed an LLC or formed a corporation, there's a chance that that joint venture would need to report. There's a question here on the website to get started. Go to FinCEN. FinCEN.com is the place where those filings are submitted if you want to do this independently. Harbor Compliance can also help you do this filing and help you manage all the details, securely store all the information so that you're not having to pass that back and forth, and generally organize the process for you. But by all means, if you want to file on your own, the BOSS portal is available via the FinCEN website. Does anything need to be submitted to FinCEN if a legal entity is dissolved? This is a very good question. The answer is maybe. It's maybe. There are some exceptions to entities that have been wound down that may need to report if they were active for a given time period during the filing window being open. So just because your legal entity has been wound down at the state level, you filed dissolution paperwork, doesn't mean that it doesn't necessarily have to report BOI to FinCEN. We actually have a blog article about this fact. There's information in our information center about it as well. I'd encourage you to check out harborcompliance.com and read more. If you qualify for an exemption, is a notification to FinCEN necessary? No. If you are exempt, then no report needs to be submitted. Now, mind you, if you're not 100% sure that you're exempt, there's no downside to reporting. There's no fees for submitting it. There's no penalties for reporting unnecessarily. So there's really no risk involved in submitting a report if you think you're exempt, just to be safe. But there is no notification of FinCEN necessary for entities that know they are exempt. Oh, I've got a good question here. So, if a company was filed in early February, does it have 30 days to file BOI or does it have until March 21st? That's a good question. Entities that were formed in 2025 have 30 days to submit their initial report. The filing deadline applies to the vast majority of existing entities. So, March 21st is the deadline that replaced the January 1 deadline that was in place all year through 2024. Now it is 2021. So it's really meant for those entities that were formed prior to 2024 or in 2024. And now we're talking about just those entities that are formed in 2025. They'll have the regular 30 days to submit the initial report. Clarifying question here on the BOSS portal. Does that equal the FinCEN portal? Yes, BOSS is the acronym for their portal, the Beneficial Ownership Secure System. Okay, very good. Okay, that about does it for the questions that I've received so far. I appreciate everyone joining us today. Love the engagement, love the Q&A. If there are more that we didn't get to, absolutely pass them over to us and we will get those answered. If there's anything at all that we can help with respect to the BOI report, don't hesitate to reach out. You can contact me directly. My email is on the screen. You can also call our main line. We'd be happy to speak with you. But overall, it's been a great presentation. It was good seeing you all. Hope you have a great rest of your day, and thank you for your time.